Now we are going to keep going, and we have Aoife Sexton here for the next session. She will be talking about navigating privacy and data governance in the era of AI. Aoife is the Chief Privacy Officer and Chief of Product Innovation in Trūata, a privacy-enhancing data analytics solution provider that specializes in privacy risk assessment, de-identification, and anonymizing of data. Aoife guides the privacy product, marketing, and data science functions, and she brings with her a wealth of expertise from her background as a privacy lawyer for the last 30 years. Aoife Sexton.
That was great, thank you. Good afternoon, everyone. I thought I misheard you there for a moment. I thought you said experience for the last 50 years. I was thinking, no, you're dating me there. I hope everyone has had their shot of coffee. I think I forgot to. So I'm going to talk a little bit about AI. Nothing like jumping on the latest bandwagon to have a conversation. So as mentioned, I work with Trūata, and let's see. Yes, it does work. Actually, before I get started, can I just say a huge thank you to Jack and the team for the invite, and also just to say what a fantastic event, and wonderful to pull together such a diverse number of individuals here, cross-functionally coming from different parts of businesses. I think those of us who are evangelists about pets really talk about the need for these types of forums to have conversations, having the lawyers talk with the technologists, have the vendors talk with the regulators, with the customers, and with the academics. We really need these type of forums in order for us to have these conversations, in order for us to educate and promote. Those of us believe that pets are going to be an incredibly important component now, but also in the future, and particularly when you see how we have challenges around the ethical and responsible use of personal data. And that's some of the things I'm going to talk about now, is some of the challenges around personal data in the context of AI. But first, just a word about Trūata. We've been in existence since about 2018, and we're based out in Sandyford, mainly a tech company, so we design and bring pets to market. We're principally known for anonymization, something called independent anonymization, where we ingest data from our customers. We're responsible for the anonymization. We carry out analytics, and then we give back aggregated insights to our customers. But that core product has evolved over the years, and we have since built new products on the back of that. One of them is something called combined analytics, because we found our customers wanted to augment insights about their customers. So we found ways using anonymized data to drive insights and augment our customers' information about their customers at a group level. We've also looked at something called Pioneer, and this is really interesting because my colleague Mike Fenton is here today, and we're kind of laughing about it beforehand that the topic or the title for today's conference is called Eyes Off Summit. And that's what we've been working on in Trūata for a while. Can we create a product where the analyst can see the data, but can do ad hoc queries on the data? So that's really cool from a security point of view and keeping the data safe. But in addition, can we also solve the privacy problem, which is, can we make sure that the output they drive from the queries will be privacy safe? And in the case of Trūata, that's a self-serve tool for our anonymization customers, where their data scientists can do ad hoc queries on the anonymized data which we hold, and we guarantee that what they can extract will be safe at an anonymization level. But we're also developing that for on-prem use, so a customer themselves can deploy that and ensure that there's a separation between the analyst and the data, and there are safe outputs there. So that's something we're working on. Pioneer, we should call it Eyes Off, but that's an interesting one. And then there's other elements of our products around Calibrate, which is a software tool that will scan large data sets. It will identify within the columns of data where the personal data lies, direct identifiers, but more innovatively, it will detect where the indirect, the quasi, the hidden identifiers lie, because it's really important as you're looking at data sets and you want to understand, is there personal data in this data set? You need to have tools that can scan and understand correlations between columns, which on the face of it might look like there's no personal data, but when you add them together, you start to detect that there is actually personal data that would single out an individual. So that's a product called Calibrate. So, you know, we're excited about bringing these pets to the market because we do believe that as customers want to innovate with data, they are looking for solutions that are easy to use, which allows them to do the right thing, innovate with data, but be responsible and ethical, and of course be compliant with the laws. So what I was asked to talk about was AI, and in particular data protection and data governance. So AI has been around for a long time, but I suppose there's been a lot of excitement about the emergence of generative AI. And in many ways, generative AI has been a catalyst for some of the conversations around use of personal data that have been in the background for a while, but have come to the foreground now that people are starting to look at generative AI. I suppose the main thing to state from the outset is that there are existing laws, and those existing laws do apply to new technologies. So it doesn't matter how cool or innovative or shiny this new technology looks, the existing laws will still apply. And there are a significant number of existing laws that will apply to AI and generative AI in particular. And I've listed some of them here. The GDPR we'll talk about in a moment. But obviously in Europe, we are aware that there's a draft specific AI Act that's going through the trialogue at the moment, and the draft AI Liability Act. So within the European Union, we've taken an approach which is to have specific legislation on this. And companies that are creating or using AI tools and technologies will need to be mindful of how these laws might apply to them. There are also another set of laws that we need to be mindful of. These are laws on human rights, anti-discrimination laws, IP and copyright law, and I'll talk about that one because that one is really being challenged at the boundaries at the moment, and employment law. So these laws also apply depending on how the AI and the models are being used. So in terms of what is the regulatory approach to regulating AI, and I think it's fair to say we're going to have a patchwork of regulation across the globe. There's certain synergies that we're seeing. So at the EU and the US level, there's certainly synergies about having a risk-based approach and also agreeing on principles of trustworthy AI and the importance of standards. But that's kind of where the synergies stop and where divergence starts. So as I mentioned, in the EU, we've gone for specific laws, so the AI Act and AI Liability Act. And then in the US, there are existing federal and state laws that will apply, along with a series of frameworks, certain federal agencies. And we're seeing also some specific AI laws, but it's very much state by state. The Federal Trade Commission, the FTC, has also outlined where it views it has jurisdiction in terms of managing AI, and we'll talk about that in a moment. But then you can see in Canada and China, they've taken a different approach. Singapore has taken more of a framework approach. The UK has published a white paper, and what they're saying is they've sort of labeled and flagged that they're going to take a proportionate and a pro-innovation approach. So we wait to see what that looks like. But there is no doubt, and there is consensus also, that guidelines and standards are going to be really important here. And so we already have the NIST guidelines and framework and the OECD principles. So moving on next, I mentioned that there are existing laws. So what does that mean about claims around these existing laws? So it's always interesting when you're giving a presentation like this, because I'm sure by the time I've sat down, some of what is here will already be outdated. But it was even last week, the FTC announced that they were opening an expansive investigation into OpenAI, probing whether ChatGPT has run afoul of consumer protection laws by putting personal reputations and data at risk. So that's kind of within their wheelhouse of where they can actually enforce. So that's interesting that they've opened an investigation. And there are a certain number of class actions that have already been filed. I've mentioned them here. One is around GitHub Copilot lawsuit. That was a class action filed in November against GitHub, Microsoft, and OpenAI about the use of GitHub's Copilot tool. There's an interesting one that was filed in January, a class action relating to 3 image generation tools. And in this case, the plaintiffs claim that the models powering these tools were trained using copyrighted images, in some cases their own images, which they allege were scraped from the internet. And then Getty Images also has taken a lawsuit in the UK against Stability AI for what it says use of protected images. And these lawsuits are really interesting and important for companies creating or using AI tools to address, because they're going to, in the first instance, look at a number of really important issues that lawyers are grappling with. For example, does training a model on copyrighted material require a license? Does the output generated by a generative AI tool infringe the copyright in the materials on which the model was trained? Does generative AI violate restrictions on removing, altering, or falsifying copyright management information? This idea of creating an image in the style of, does that violate the artist's right of publicity? And then finally, how do open source or Creative Commons license apply in connection with the use for training AI models and distributing? And the answer is we have to wait to see where the courts might land on some of these questions. So it's very, very interesting. I also mentioned that the AI Act is in draft at the moment, and many of you may have seen the fact that there has been, Stanford has taken a crack at a scorecard to see if these foundation model providers today were saying they were complying with the AI Act, how would they score in terms of the AI requirements? And the AI requirements, if we're looking at data, they do talk about, as a requirement, describe data sources used to train the foundation model. In relation to data governance, use data that is subject to data governance measures like suitability, bias, and appropriate mitigation. On the issue of copyright, there is a requirement that you summarize the copyright data used to train the foundation models, and so on. There's a number of other requirements. But suffice to say, when you look at the scorecard, nobody is knocking it out of the park in terms of complying with the AI Act as it was looked at in draft. Now, that Act, ultimately, once it's finalized, may change, but they took it at a point in time. And you would say that there is quite a gap, in many cases, between where they are in compliance today and where they would need to be in terms of compliance with the AI Act. So let's just turn for a moment and talk about the GDPR in a little bit more detail. So the GDPR is a principle-based law, and these principles must be complied with when personal data is used in conjunction with AI systems. This isn't a new idea. AI has been around for a long time, and GDPR has been now in existence for 5 years. But there is absolutely no doubt it is creating tension and is in the spotlight at the moment with the arrival, in particular, of the hype around generative AI. And the GDPR principles will apply to training data when it contains personal data, text, images, etc. And in the case of generative AI, when you prompt using personal data or in terms of the output data. So if you think about it, if there's generative AI models are being trained on materials scraped from the internet, the training data will often contain a large amount of personal data. In the case of image generators, they're often trained on huge data sets that includes images of real people. And these images can be taken from social media and search engines, very often, without a lawful basis, or knowledge by the people in the pictures. And similarly, with text generators, they're often trained on data sets that could include personal data about individuals or conversations. So, that's the reality of what has been happening for a while. So let's switch and look to the GDPR principles themselves and see how they sit alongside the practice. So, data protection by design and by default requires you, when you're designing new systems, to make sure that data protection is front of mind, not an afterthought. Transparency. You need to be upfront in your policy about what data, personal data you're using, and for what purposes, and your lawful basis. Purpose limitation. Only collect what you need, no more, and only retain it for as long as you need. Data minimum, lawful basis, that's an interesting one, I'll come to that in a moment. Every act of processing under the GDPR requires you to have a lawful basis, and you must state what that lawful basis is. And fairness and bias, that's obviously an important one in the context of AI. But there's two other important articles in the GDPR that reflect and relate to algorithmic decision making. The first one, in general, says that algorithmic systems should not be allowed to make significant decisions that affect legal rights without any human supervision. So human in the loop, not automated. And secondly, an individual has a right to meaningful information about the logic of algorithmic systems, explainability. That, you can see, is already going to create some issues in terms of the black box, what goes in, how does it make decisions, and what the output is. Interestingly, on the transparency issue, those of you may have read in the last week or so that Google recently updated its privacy policy with a small but a meaningful update. It had previously declared that it used public internet sources to train language models, naming Google Translate as an example. But this policy change has now been changed from language models to AI models, and Google specifically names current projects like Bard and Cloud AI. So, you know, just from me running through what the principles are and putting that in juxtaposition with what the practices are, you can see where the tensions lie. And it's going to be interesting now to see how the regulators respond. And on that point, so what has been the response of the regulators to date? So in March, many of us are aware, the Garante, the Italian DPA, issued an order against OpenAI to stop processing personal data in Italy following concerns that ChatGPT breached the GDPR. It later suspended the order, seeing improvements in previously flagged aspects. OpenAI published a privacy notice to users worldwide to inform them about how personal data is used in the algorithmic training and emphasized the right to object to such processing. The Spanish and Dutch DPA have also signalled they're looking into it, and the European Data Protection Board, which coordinates all the DPAs, said we're actually going to take a coordinated response. We're going to take this away and have a look at it. In Canada, there's been an investigation open to ChatGPT, Japan the same, and I mentioned that the FTC has opened an investigation as well. So it'll be interesting over time how the regulators respond and what guidance they give to these foundation model creators around the use of personal data when it comes to these models. I mentioned earlier as well that every time you process personal data, you need a lawful basis. And the GDPR is 5 years in existence now. And because it's a principle-based law, there are times where there are elements of ambiguity. And as practitioners, we wait to see when we're going to get guidance from the regulators or from the courts around some of these aspects. And I'd say in the last 12 to 18 months, we've started to get more and more guidance, often from the DPC in Ireland. And we can then read the decisions and why they took a decision, an example against Meta, and we can see what the views of the other regulators has been. So it's been incredibly useful for us to start to get some guidance. We're also seeing some decisions from the CJEU, and again, it's giving us some more clarity. But one of the areas that they've really honed in very recently on is around a lawful basis. And if we take just as an example and as, to illustrate just how difficult it can be sometimes to find a lawful basis to ground your right to process data, we only have to look at the Meta case. So in December 2022, the Irish DPC issued a decision and found that Meta could not rely on Article 6.1b, and that was the article necessary to perform a contract, which was what they were relying on for personalized advertising. And Meta was ordered to bring their processing activities into compliance. And what they did was they said they were going to move to legitimate interest as their lawful basis. Just very recently, on the 4th of July, the CJEU had a case before it which was referred from the German Competition Authority. And in that case, they took a look at lawful bases. And it was interesting in that case, it was around Meta again. They formed a conclusion that they didn't believe that Meta could rely on legitimate interest for the purposes of personal advertising. And then the Norwegian DPA, only this week, that's why I'm saying probably by the time I sit down something else will have happened, had concluded that because Meta had been ordered to bring its processing operations into compliance, and because the court said that they hadn't done so and reliance on legitimate interest wasn't open to them, the Norwegian DPA decided that it would stop use of Meta in Norway, and the reason it did that was it said there was a persistent state of non-compliance following the DPC's decision, and it demanded an immediate action to protect the rights and freedoms of European data subjects. It had said that the Irish DPC had found serious violations of the GDPR, and that if there was a delay to remedy that, individuals would be put at risk, and therefore it has put in a cessation order, a temporary ban on Meta's processing of personal data of data subjects in Norway where they're using targeting ads. So that's just an interesting footnote to where an individual DPA stepped in and said, look, we think there's a sense of urgency here around personalized advertising and reliance by Meta on legitimate interest. We're putting a ban in. The EDPB will now have to look at it, and also the DPC. So the point on this is trying to find a lawful basis is difficult at the best of times, but trying to find a lawful basis if you're scraping public sources, creating a database, you have to think about what might be the lawful basis there. In many instances, consent and granular, informed, unambiguous consent is going to be really difficult to get. So a lot of companies will try and rely on legitimate interest. And that brings me nicely to pets. So just to finish off, this is a pet conference. We're here to talk about whether and how pets can solve some of these challenges. And there's no doubt in my mind that pets are going to be an incredibly useful tool for companies as they look to try and ground their lawful bases around use of personal data. So, for example, if you think about it as a sort of a flow chart, in the very first instance, if you're looking at training data, you'd have to ask yourself, do I need personal data in the training data? Could I use anonymized data? So that might be the first question. Could I use synthetic data? Looking at the output, is there personal data in the output? How would I know? And pets, like the type of pets that we've developed within Trūata that can scan data sets and find whether you've personal data, direct or indirect identifiers, are very important. But also if you said, okay, it's not going to be anonymized, it's still going to be personal data, but we need to safeguard that data on behalf of the data subjects, what other pets could we use? So you could look at trusted execution environments, or perhaps pets like homomorphic encryption as well might be useful in order to protect the data as well. I mentioned Pioneer earlier, eyes off, ways of securing the data to make sure that a limited amount of access to the data. But obviously you need to look at the privacy element as well in terms of the output and make sure you look to mitigate. So, you know, as you look at the direction of travel, there is no doubt, and as we look at the regulatory guidance and the cases and jurisprudence that's coming out of CJEU, there is no question but that we're getting much clearer guidance on the enforcement of the GDPR, and pets are going to be instrumental in how we try and protect data, protect the rights of individuals, but also still get to innovate with data, still get to share data, and still get to collaborate with data. Thank you very much. I think I'm over time, so